Taxation at the Jindal Global Law School. It aims to serve as a hub for tax related discussions, fiscal policy coverage, and tax news dissemination. It serves as a forum for facilitating knowledge sharing on contemporary challenges in the fiscal arena. At present, there are four segments to the tax terminal. The first being tax bulletins that offer quick news bites regarding critical fiscal developments around the globe. The second segment is the tax resources segment, which provides study references and guides on crucial issues in the tax domain. Thirdly, the tax terminal offers Tax Wit that features a humorous post every day. And lastly, we have the Bricks and Bytes, which features a tax related crossword every week covering wide areas of taxation. Uh, now, over to Supriya, if you could kindly introduce our guests today.
Firstly, I would like to request Sir, if you may please record the session. Hello, thank you. Sir, please, if I may record the session.
Yes, you please go on. Yeah.
Session today, we have a personality who has more than a decade and a half experience of working as a civil servant, having served at different public positions, including Additional Commissioner Income Tax and Deputy Commissioner Income Tax. Additionally, with a career span of over 9 years in academia, the feathers to his crown are numerous. He is none other than Dr. Shafiu Khan Naizi, an academic at at the Department of Business Law and Taxation in Business School, Monash University, Australia. Dr. Khan holds three master's degree, including masters in business and commerce and taxation policy from Tokyo, and a doctorate from Monash University, Melbourne. Sir is a former joint Japan World Bank scholar and has also attended the prestigious International Visitors Leadership Program of the US State Department on Federal Taxation at Washington, D.C., the state taxes at New York City, city taxes at Oklahoma City, and county taxes at San Francisco and Sacramento. Sir's area of research is international and EU taxation, tax policy, and anti-avoidance and tax compliance. Sir has presently presented his research work in conferences and seminars worldwide, and his work has been published in reputed journals in Australia, USA, Canada, and Europe. Sir, we are truly elated to have you with us. Today, we also have with us Ms. Sana Zaved, Lecturer of Taxation Law, Jindal Global Law School. I welcome you, ma'am. Without further ado, I now request Dr. Shafi sir to kindly enlighten us and walk us through his article, Pricing-Based Profit Shifting in Europe, the recent judgment of the General Court of European Union. I also request all the participants to kindly post their questions, if any, in the chat box, and we'll be taking them at the end of the session. You, sir, now.
Well, thank you very much. Thank you, Supriya. Thanks, Samir. Thanks, Sana. Thanks all the team, the Tax Terminal and the CCIT webinar. Well, I will be just taking a few minutes briefly touching some of the issues that I'm sure many of you have already gone through if you have had a chance to an opportunity to look at this particular topic. Well, this is kind of a transnational topic, comparative tax issue, a very hardcore and comparative tax issue that has been in the news also recently since the Apple got taxed in the European Union. So I'll be looking at this particular uh, discussion. This is just the overview of the discussion that we would have. I will try to keep it as brief as possible because keeping in mind that many of you have already gone through all those things. That will be touching upon a few things that are maybe could be additions to what we have already written on the blog. There have been certain new developments as well going on, so I'll be expand on those. So first of all, what the issue in fact is, if you just have the opportunity to look at the blog. So the issue was the pricing-based profit shifting in the European Union. And it's very unique in the European Union that what happened was that there was a so-called nexus between certain EU member states and some of the multinational companies of household names like Apple, Starbucks, Amazon, Fiat, Nike, IKEA, many of other still going on. The investigations are still on. What happened in these cases were that some of the European member states like Ireland, maybe Netherlands, also Luxembourg, they were issuing some kind of the tax rulings, what we call, to some of the companies. And those tax rulings were in fact the pricing-based tax ruling, what we call the advanced pricing agreements. And subsequently, the European Commission came to know through various ways that those were underpriced. So in a way, there was a profit shifting element in that. It would take how long, maybe big session for that actually why it happened and how it happened and all those things. But I'll be happy to discuss some of those when we take those comments and questions from you guys. So what the European Union did, in fact, that they don't have the powers to enact tax legislation. They don't have the power at all under the EU treaties. So they used another method, the powers they had, to what we call here, you can see the use of state aid law, the anti-subsidy law. So they actually use this particular tool, which in fact is a kind of what we call the market repair tool in ordinary terms. So whenever there's some distortions or there are some competition which is not fair competition, so you can use these tools. So they actually use this particular tool to tackle, to in fact combat that particular profit shifting, all those measures. And when they did, they in fact, you can see here 13 billion. They asked the Apple to pay 2 million, 23 million. All those, you can see those huge amounts of money that were being transferred. The profit was being transferred, so revenue was being lost. All those companies went to the court immediately after the commission made decision, and we can see that in many cases the commission lost those cases, except for those green where the commission actually won in a couple of cases. And then the commission has contested those judgments now before the Apex EU court, and the issues are ongoing. For the what we have right at hand, you can see this last one, Nike versus Commission, the issue at hand. What happened in this case was that this was perhaps the first case where European Commission won, and coincidentally the company or the MNC in question was an American company. Before that, whatever cases where they won, they were the European Union, the European companies, in fact. So my, in fact, point was about that particular issue when I posted that on you guys' blog. So what's Nike case and what's different about it? There are a few things that, again, I'm sure I won't go into much of those details. I will take, of course, questions, and I would expand on those. So they might get some clarity when we do that. But you would see that there are, on facts, they have some distinctions. On law, they have some distinctions. They're distinct from the previous cases, whatever have been decided. And on politics in particular, and politics and political spillover that actually goes beyond Europe and the European Union, because the American interests are involved. American big companies, build multinationals, are involved with huge profits, lots of revenues involved. So they do have their own political consequences and what I call the transatlantic tax and trade ties issues. So how actually that would happen, that's is another consequence that might actually come up. So I won't go into much of those details, assuming that you guys have read through, but when we do those, that would be, and question and answer, I'll expand on those. A few things before we go to those question and answers. The Nike case, we keep something in perspective, and that would make certain sense that why this Nike case is so much important, that I was talking about an American company where they were being investigated by the European Commission under the state aid rules of the EU, or what we call the anti-subsidy regime of the EU, that at the background you can see there were lots of outcry when the European Union started in those investigations. When the European Commission did that, the US Chambers of Commerce, you can see during 2015-16, American Manufacturers Association, all of those are claiming that we're being treated pretty discriminately, and there's a discrimination in there. Those investigations, the EU is not empowered under the law to conduct all those kinds of investigation and so forth. And there was exchange between the US, then US Treasury Secretary. Of course, we don't have the same person right now. It's a different US Treasury Secretary these days. But at that point in time, there was exchange of letters, communication that what's going on and all those things. And the interesting development took place when, you can see here, when in February 2016, Professor Greenberg from the Georgetown University, actually in his testimony before the congressional testimony before the U.S. House Means and Voice Committee, well, referred to this section 89 of the IRC, or the Internal Revenue Code, the tax legislation of the United States, saying that if the United States president thinks that their citizens or their companies are being discriminated for taxes somewhere else, so they have the power to tax them, maybe double, to twicely tax them if something happens. This kind of provision has never been applied. In fact, this provision is part of the IRC since 1930s. But that was one very interesting development when it was put forth by Professor Greenberg in his testimony. Then the US Treasury published a white paper in August 2016, just a few days before the Apple decision was made by the Commission, where the Apple was required to pay $13 billion. So all those things were actually are at the background when we look at this Nike's case. So what happened when all those cases, they were decided against these companies by the European Commission, when they went to the court, Starbucks, Apple, Amazon, all of them won, in fact. So things were kind of like, maybe there was kind of appeasement to the extent that, oh, okay, we are getting something from the court, and the courts were not ready to accept the Commission's call, whatever they were doing. The Nike would be the first case, in fact, where the things have gone the other way. Although it's not identical to the previous cases in many ways, even on the facts, but that is something which is different. So in Nike's case, no, the thing would be how it would take shape. Well, they are, of course, would have to see, because now the case has gone back, whether the European Commission would be investigating it afresh, because they were contested before the court by the Nike when they were in between the proceedings. Those were the preliminary proceedings which were contested before the court, not the final proceedings. So now the Commission would be perhaps moving towards the final proceedings, if provided, again, is a big if, that if Nike do not contest this particular case before the highest forum, or the apex EU court, what we call the European Court of Justice. Okay, things could entangle further between this transatlantic, all the trade and tax ties, because in fact, there have been all those things going on for the digital tax as well. You can see that from the US side, Austria, Italy, Spain, United Kingdom has left now, it's after Brexit, the EU, but there were some proceedings going on from the EU side also, from the US side also, initiated by the Office of the US Trade Representative under Section 301 of their Trade Act, and saying that when you tax the digital taxes are discriminatory in nature, you can't do those. And in fact, India was also part of those particular countries. I haven't mentioned it because I was looking at it from the EU, US perspective. So all those proceedings are, in fact, and those things are taking some shape. And even investigations have gone against those countries, although US put a pause on those for 180 days when those decisions were made on 2nd of June 2021. And so it's by 180 days being until 20th of November 2021. But how things would shape after that is again a big question. Okay. What does the future hold? Well, we don't know right now, but only time will tell, of course. For now, this last sentence, maybe I just went through from Golder's recent publication. Golder is a Washington-based US international tax specialist. His article names Stand Down Margrethe. Well, this in fact draws on a very famous, there was a big tune, a very famous tune, Jamaican tune, which said Stand Down Margaret in late 1970s and early 1980s. And that was kind of a slogan against Margaret Thatcher, asking her to just leave the public office. Ultimately, in fact, she left office in 1990, not voted out by the opposition, but by her own fellow conservative people. So uses the same against, because the EU competition commissioner who is looking after all those things happens to be Margrethe as well, Margrethe Vestager. So it's kind of a just analogy being drawn here, but what those slogans are on the horizons that she should maybe, or maybe should not, but whatever, is just a kind of analogy that these kind of resonances are on the horizons. Any questions, comments? Many gaps were there in between, which I didn't try to fill in consciously, thinking that might come up in your questions. So I would welcome any questions, any comments from you guys, from students, from faculty, from anyone. Thank you.
Thank you so much, sir, for such an articulate and riveting speech. It was indeed an insightful session, and I'm sure it was a great learning experience for all of us attending this webinar today. So I will be taking the questions now, and I request all the participants to post their questions in the chat box if they haven't already posted them. So the first question that we have today with us, sir, is what is the mechanism by which the concessional ATRs and APAs aid in profit shifting?
Yeah. Well, the mechanism, in fact, is that maybe one thing, the basic thing that we should understand if we are the tax law students, that the tax authorities, every country has its own tax authority. For instance, India would have a tax authority, maybe Directorate General of direct taxes or something, and like we have here Australian Taxation Office. So tax authorities usually issues those tax rulings. Those tax rulings, we call them usually advanced tax rulings. They are in order to facilitate the people on the forthcoming affairs, what would happen in the future. Multinational would seek these kind of tax rulings very often before moving into a particular country, taking their capital there, doing those foreign direct investment. They would ask the tax authorities, what would happen in such and such situation if we do like this? And they would issue some kind of an explanation. We call it a tax ruling. Those tax rulings, of course, are generally not binding on the taxpayer. Of course, they're binding on the tax authority. But what happens in the case of the advanced pricing agreements, they're also one of the forms of the advanced tax rulings, is that these are agreements. They are kind of a contract between the private party, means the company, and the tax authority, the commissioner or whatever the head of the tax authority is. That we would agree on these kind of pricing arrangements, that if such and such things happen, those would be the acceptable limits of pricing. So we call them advanced pricing agreements. So the company then would come and would do some whatever their activities. The famous case that all of these cases, in fact, involve these kind of situations differing in different contexts. For instance, the Apple's case, which is the flagship case, in fact, in these situations, there were a couple of advanced pricing agreements issued by Ireland to this company, first in 1991 and second, I think, around 2004 or somewhere, or 2007. And both of them have now subsequently been viewed by the European Commission that they were kind of a sweetheart deals. They were underpriced. So through which, if it's underpriced, for instance, for Apple, if we look at all those commission's decision and look at those, what happens is that although Ireland has to charge tax at the rate of 12.5% on the turnover or on all the revenues from this particular company, their taxable profits, but in factual position, it was less than maybe 2%, which was taxed due to this transfer pricing arrangement, which came into effect due to this advanced tax rulings issued by the Irish tax authority. And of course, it was a kind of agreement between the Apple Ireland affiliates, Apple's affiliates working in Ireland, and between the tax authority. So they are kind of a tools through which the profits shift from a higher taxing jurisdiction to a lower taxing jurisdictions, or do not get taxed anywhere. For instance, in the Apple's case. So we were done with, I think, the first question. Maybe we are running.
Yes.
Yeah. So next, anything? Yeah. Any other question? Any other comment?
Yes, sir. So the next question that we have for today is, how do the countries benefit from the issuance of selective pricing-based advanced tax issuance?
Yeah. Well, what happens is, in fact, that countries usually would like to have more and more FDI, many companies coming to their jurisdictions doing all those kind of things. So companies usually would take benefit Although there's a lots of literature, some of it is a bit of ambiguous, but usually what we see in these particular contexts is that it's kind of a tax competition issue, what we call the race to the bottom, or the what we call the beggar thy neighbor approach, we usually call. So the countries and would usually be doing this for their benefiting more and more from the foreign direct investment, the capital that would come into them. So that could be predominantly the main reason behind issuing these kind of tools, where the other countries, the other companies might be doing profit shifting. And in fact, the benefit for the jurisdictions where they operate is that they would take benefit of all those foreign direct investment, and also the incidental things, the scale coming up, the know-how, all technology, those kind of things would be the key incentive usually for the issuing authority. Yeah.
Thank you, sir, for highlighting that for us. The next question that we have is, what is the way forward to regulate and avoid the pricing-based profit shifting in Europe?
Yeah, well, that's a bit of a maybe trickier question, but I think the first thing first is that what the European Union is doing right now is that since they don't have any the authority or the legal authority to enact tax laws, the EU-wide tax laws directly, because they are the prerogative of the member states. So what they have done is that, in fact, they are predominantly relying on their anti-competition regime, which is in the hand of the EU. But to be looking at from an academic perspective, when you apply these anti-subsidy rules, what we usually would call is the like kind of a market repair rules, which is meant for market repair. They're not, in fact, basically meant for anti-avoidance, which of course is the tax domain, tax rules, what they call. So what the European Union can do, in fact, is that they should move towards more of a legislative approach, number one. And number two, maybe if you allow me to share, I don't know whether the screen share works here. So if the screen share, in fact, I can't share. I could have, in fact, shared one particular article that we recently, in fact, published. It was the 1st October publication. It was an article in a very reputed journal, Australian Tax Forum. I wrote it with my co-author, Professor Richard Kriva, and in fact, we tried to analyze. That is something which, of course, is beyond the scope of this particular discussion here. But this is one where we look at the different options available to the European Union, what they could do. And of course, the key thing, or what maybe in a nutshell, what I can say is that the ultimate solution to these kind of issues lies in the multilateralism and some kind of maybe new ways to look at the international tax rules. So that in fact is the ultimate solution. Could it be the formulary apportionment? I'm not sure you guys are familiar with that, because formulary apportionment is something which the United States, in fact, they do wherever the states have taxes, where states have income taxes. The formulary apportionment is perhaps Canada has the same, in fact. In fact, in Indian perspective, you guys may not have, because your states may not have the income taxes. When the states have income taxes, these issues come up. And the formulary apportionment is one way where these transfer pricing issues would not arise if you have put in place this formulary apportionment. What the European, in fact, context, they call it CCTB, the Common Consolidated Corporate Tax Base. This is one proposal which is ongoing, but haven't been materialized since 2011. So those are some of the ways out. Yeah.
Thank you, sir, for guiding us through the further proposals. The next question that we have is, what could be the possible steps that may be adopted by the countries in order to avoid the brewing EU-US tax war?
Yeah, well, this, in fact, maybe should be a bit of an exaggeration. We use the word war itself, which of course many academics and bloggers have done since the Apple taxation 2016. But I think those kind of tensions would exist unless there is, again, multilateral solution to that. So what other countries could do, I'm not sure what the other countries' role would be, but of course, other countries might have a bit of a role in the sense that the developments which are right now taking place under the umbrella of OECD, where there is a inclusive framework. 140 countries are sitting there. 136 of them have already signed a tool as well. In fact, yesterday they did sign a tool. So other countries could contribute to that in a way that a multilateral solution should be approached. The current existing international tax rules should be amended to the changing circumstances, to the changing business models that we have to do, because the international tax rules on which many nations have agreed, they are 100 years old. They are meant for the physical shops, physical stores, and all those kind of, not for the digital, all these kind of things. So in fact, the multilateral solution would be the key thing to look at it, how to go about all those issues and how to put in place the different, for instance, also there's a development you guys might have listened to, the global minimum tax rate, the pillar 2, to which in fact again the OECD members have agreed. So having those kind of international tools put in place where the other countries do have their role to play, and they could facilitate these kind of multilateral solutions, agreements, or conventions, so that those could be some of the ways out where others can also play their role to mitigate some of those tensions that are developing transatlantic between the EU and the United States. Yeah.
Thank you so much, sir, for the answer. I totally agree with you on the multilateral approach. I would now request Samir to please take over.
Thank you very much, Supriya. So the next set of questions, I would like to ask you the next set of questions. Uh, Nike had challenged the provisional decision of the European Commission, and now it has the option to contest the judgment before the Apex EU court. However, if the formal investigations will conclude to the dissatisfaction of Nike, they might also contest the European Commission's final decision. Will this strategy adopted by Nike set similar trends for other corporations that wish to delay the proceedings initiated against them?
Yeah, yes, that's a good question. In fact, well, those could be some of the delaying tactics which many businesses do. But in fact, what Nike did different from many of the cases that have surfaced until now is that they contested the European Commission's decision, which wasn't mature, which was right in somewhere in the midway. So it was a what we call the preliminary investigation they contested. So this might actually, for instance, now if they have lost the case, it does not mean that they have to pay taxes. Rather, now it's the European Commission would do the formal investigation. And when, for instance, if they ask them to pay taxes, they might contest then the formal investigation. So it's kind of a time waste. I understand your point. So many companies might also do that. That potentially could be, but I think at the end of the day, for the smaller taxpayers, they do have these kind of leverage to delaying tactics and all those. For the multinational companies, bigger multinational companies working across lots of whole range of jurisdictions, they don't want to keep things in uncertainty for longer. So I think it won't be beneficial for any company to keep things in litigation for a longer time and keep it a multiplicity of litigation would not add any kind of a, unless if there's some exception in some certain circumstances. So I think it of course is a kind of a one precedent where other companies might follow to prolong the litigation. But at the end of the day, the bigger companies do not, and of course, most of the time they cannot afford the uncertainty, which this, and of course, the cost is another thing. It's not that you're just litigating and you're prolonging, rather you're bearing the cost as well. The legal costs, all those things, they are ongoing. So it could be a mixed kind of response for that. Generally, I think for these kind of companies, it's not a very useful precedent to keep litigating those kind of first litigate the preliminary investigation, then litigate the final investigation, keep litigating. So there's something pretty much not a cost-effective way, in fact. Yeah.
Thank you very much. So that clears a lot of doubts regarding those points. The next question is the United States seems to be adopting a similar approach when it claims the European Commission's investigation to be targeting US companies disproportionately. And the investigations initiated by the Office of the US Trade Representative against the digital services taxes imposed by certain countries such as India, Turkey, Italy, US, sorry, Spain, and the UK. And they have been claiming that these taxes have been imposed discriminately against US
Yeah.
companies. What would be your comment regarding the United States retaliatory approach on these nations?
Well, that's I think one of the most important questions of the day in the international tax arena. On the one hand, you can see the US is complaining that, well, we are being disproportionately targeted, our companies. On the other hand, in fact, US doing it in some other garb, in some other way, with a different manner. But that's a good question, in fact, and also it brings to the fore many issues. Well, those issues are now on the way to a solution. I will talk about it because the yesterday's development, 8th of October, yesterday at the OECD, was a bigger development that I will talk about. In fact, that covers these kind of questions as well. But first thing first is that the US, I think I talked about in my discussion as well, that the US trade representative had been doing these kind of investigation, and the lady heading that particular, Catherine, who in fact did I think in my case, I talked about the European nations only. They, in fact, have also included some of the non-European, including India, Turkey, United Kingdom itself, in fact, who is not rightly the part of the European Union. Well, one thing is, it's very important to understand that one thing, number one, well, whether the US can do that or not, it's the US own law. They have a trade act. So under Section 301, whenever their US trade representative feels that their companies or their businesses or they're being treated inappropriately or being discriminated against, they can take those actions, which in fact they did. For instance, let me take the very relevant example of India. What happened was that India introduced this equalization levy, 2%, I think in April 2020. And since then, it came within that particular menu where all those companies were before all those countries were before the US that they wanted to investigate, and they did investigate the Indian case as well. They started it somewhere in January, and on 2nd of June, all those 5-6 nations that did mention, including Austria, Italy, Spain, Turkey, United Kingdom, and India, they in fact thought that they have levied these digital taxes in different names. For instance, India, you might have the name of an equalization levy. Different countries have their own names. So they thought that that was discriminatory in nature, and they also imposed the punitive tariffs. For instance, in the Indian case, they had a whole big list, 40 different items, where the 25% these tariffs would be higher than the normal one. Those items included basmati rice, furniture items, some shrimps, many other things. But at the same time, the moment they actually passed this order on the 2nd of June, they suspended it immediately for all those countries, including India. And they gave it a time of 180 days, which in my slide, I said that it is on pause until the 29th of November. So it is right now, it's kind of has been held in abeyance. Order has been passed to bring those punitive actions, punitive tariffs on some of those trade items that are imported from India by the United States, but at the same time, they held it in abeyance. And the same is the case with other countries. So what would happen is something which is unfolding. But the bigger change has come up yesterday, in fact. On 8th of October, this inclusive framework, which is working there, they have agreed on a couple of things on Pillar 1 and Pillar 2. Pillar 1 is relevant to this one, in fact. What they have agreed, out of 140 nations, 136 nations did agree that, okay, what would happen is that US is ready now to give some of the taxing rights to the market jurisdictions. Because in our case, for instance, in India's case, you can imagine, or for that matter, for the European nations, they think that those particular companies, they are not paying out any taxes, but they have income they earn from us. US, on the other hand, says that under the international tax regime, they don't have a permanent establishment. Why should they pay taxes? Because the old PE or the permanent establishment is for the physical kind of all those businesses, not for those models which have emerged right now. And whenever, also have a look at it, that whenever in the past such issues would come up, they would be resolved under the double tax treaties. So on one, to a degree, the US stance looks kind of feasible and does have a legal force, that when you have already agreed to us, any country, including India or any other EU nation, and that we will resolve issues under the double tax treaty. So now you have levied a tax outside the double tax treaty, because this equalization levy or digital taxes are not covered by the double tax regimes. They do not, in fact, if you apply on double tax treaties, perhaps they would not get taxed. They would not get caught their profits, because they don't have any physical existence. Now we are talking about the digital economic presence and all those significant digital presence. Those kind of rules are coming up. Previously, in fact, it's an interesting point also, maybe a bit of lengthier answer, shorter question, but a lengthier answer, is that multilateralism was key to it, which was lacking due to the previous US administration. You can look at all those multilateral, look at the climate and all those things. In the previous Trump era, everything was in fact kind of in limbo. Nothing was moving forward. So after the new administration has come up, all multilateralism has again reactivated. That this is perhaps one of the outcomes, that now the US has already agreed to a degree that, okay, the market jurisdiction would receive something, provided now that the market jurisdictions should not tax us on the digital taxes. And the development that happened on the 8th of October yesterday, 136 these countries have agreed that no new digital tax would be levied from 8th of October to the 31st of December 2023. And in between, what the US has already surrendered in a way is not the US, but it means that all the companies, digital companies, because bulk of the digital companies belong to US, so by default the US comes to the fore when we talk about it. So they would provide some rights, taxing rights, and it is estimated that $125 billion of annual income profits, which were previously, of course, the US right now, would go to the other countries. But in a quid pro quo, in exchange, the other countries would not levy digital taxes. That the countries would not, they have agreed. But what about those? For instance, you talked about Indian case. They already have levied a digital tax, a few other. So those are held in abeyance until the 20th of November, 2021. If they don't remove those digital taxes, the punitive tariffs would come into picture. So now expeditiously things are being resolved. What would happen from now until the 29th of November are the key developments that perhaps is kind of a issue that for all international tax students or analysts or experts would be something to watch for and to look for how things unfold, in fact. Yeah.
Thank you very much, sir, for explaining the situation so minutely. The last question that I have for the day is, what are the political consequences that the global community might expect, especially from the US, against such investigations by the European Commission?
Yeah. Well, if the European Commission, in fact, the way they are doing, and in fact, their things are going on, there are many other cases still coming up, the litigation also in the hands of the European Commission. So I think that one option, perhaps, as already mentioned, that one was the testimony by the Professor Greenberg before the Congressional, that they had the power under Section 891 of their income tax law, that they can, the US president can double the amount of taxes of those particular countries or those particular jurisdictions who deal with them on a discrimination-based taxation. So those are some of the very harsh options. Of course, very hard to say that they could be pursued, but those are, of course, some of the options. But given what, if you ask my personal opinion, because that's something which I'm not talking out of the literature or the existing scholarship, but what I think is that given the momentum which the multilateralism has now taken, and in particular in the international tax arena, and in particular post Biden era, when the earlier administration has gone and things of multilateralism, everything has come back, it looks like these things would get resolved perhaps on the table under the umbrella of either OECD or some kind of a multilateral convention or something. So it's not something like the way the people used to look at it from 2016 to the 2020, the kind of a EU-US tax war or the transatlantic tax or trade war. Yeah, but coming back to your question, I think that US would try to come back to the table also, the way they already have been, and those are the biggest developments on the Pillar 1 and Pillar 2, to which many countries have agreed. US also agreed to that, and all those things. So I think possibility is that things would be solved under the greater umbrella at the international cooperation level, using those multilateral tools and all those. Yeah.
Thank you very much, sir, for this articulate and insightful explanation. Um, if there are no other questions from the participants that we have today, I would seek permission of Professor Preeti Chawla to end this session today, and would begin my vote of thanks. Thank you very much, ma'am. I take this opportunity to thank Dr. Khan and express my kind gratitude on behalf of CCIT for accepting our invitation to address this session. We strongly look forward.
Yeah.
We strongly look forward to having with you again with us, sir. And without failing to mention, I would also like to thank all the participants who joined this session, without whom this webinar would not have been successful. And on behalf of CCIT, I assure you that we will continue to strive for knowledge, and in furtherance of the same, we will continue to bring up such expert sessions to ameliorate everyone's taxation knowledge and understanding. Thank you very much for joining us this afternoon.
Thank you very much, all of you. Thanks for having me. Thanks to the CCIT. Thanks to all of you guys. Thanks for those being here. And my, again, apologies for those bit of a technical glitch that came up in between, but thank you very much. Thanks all of you.